So, hello everyone, bom dia a todos e todas. É com um imenso prazer que damos início ao nosso 27º Diálogos em Direito Internacional e Direitos Humanos. Hoje temos o prazer de contar com o professor Jeffrey C. Brooks, que vai tratar sobre o tema do direito de nacionalidade por nascimento nos Estados Unidos. Professor Jeffrey is a longtime friend who is a professor of professional practice at Louisiana State University in the United States. He is currently the director of the LSU Paul M. Ebert Law Center. He has a JD from Tulane Law School, New Orleans, Louisiana from 2006, a BA from Vassar College in New York from 2003. And we are very excited to have you here. Thank you for taking your time and accepting our invitation so that we could have this dialogues in between international law and human rights on this very up-to-date topic. The floor is yours.
Thank you very much for having me. This topic is of great interest to me. I am doing a lot of research currently on statelessness and the revocation of nationality. And so the U.S. Supreme Court and the U.S. President's active involvement in that area of law is interesting, exciting, and a little scary for me. So it changes in the U.S., it seems, on a everyday basis. We have new executive orders as of 6 days ago on this very topic. So my plan is to talk through what citizenship and nationality has been in the United States, what the Supreme Court of the United States did earlier this year, and where we are now. Please ask me questions. I like questions. My students love to interrupt me, so I'm used to it. Do not hesitate to ask me questions or tell me to slow down because I talk very fast. American nationality law, as much American law does, comes from the English common law tradition. At the founding of the United States of America, there were 13 different colonial states. All 13 of those colonial states had some idea of birthright citizenship coming from the English common law tradition that anyone born in the Dominion of England owes allegiance to the Crown of England. They're natural born subjects of England. That idea came over to the English colonies on the east coast of the United States. I'm in Louisiana, which was originally a French colony in the United States, but also brought in that English common law tradition into its civil code. So throughout all of the colonial areas of America, in North America, this English common law idea that if you are born on the soil, you owe your allegiance to the crown became accepted as part of unwritten, uncodified American law. It was not originally written in our Constitution. It's nowhere in our founding documents. It was just sort of understood that if you were born on the soil, you owe your allegiance to the crown. Obviously, we had a revolution throughout the crown, but that idea that if you are born on the soil, you are a citizen continued into very early American law. Common law, not codified anywhere. Most scholars in early U.S. thought accepted this. It was just known that subjects became citizens. Jus soli was settled. No one was really questioning it. We saw a facet of that problem with the Native American Aboriginal groups who were interacting with early American white settlers. Those groups were treated as at least somewhat sovereign, separate states. And so Aboriginal children were not treated as citizens of the new United States. They were considered citizens of dependent nations, which has been I could do a whole separate talk about the American treatment of Aboriginal peoples in North America. It's not what we're here to talk about, but I could talk a long time about that. But the founding idea of the United States of America was that this was a country built for largely immigrants from Western Europe. Early American writers called the United States an asylum for mankind. And so the idea was if you came here, you were born here, you got to be a citizen of this place. That was uncontroversial for about the first 75 years of American law. It came before the Supreme Court of the United States in a different way in 1812 in a fairly famous case, the Schooner Exchange versus McFadden. Exchange was the name of a ship. A schooner is a type of ship. This warship docked in a U.S. port, and McFadden tried to seize it, said that it was a ship that he owned, but it had been refitted as a foreign warship. The Chief Justice of the Supreme Court of the United States said that that warship was immune from jurisdiction. And you're thinking, what does that have to do with our discussion about nationality? That was the first time our Supreme Court talked about the idea of use solely. And if you think about our citizenship question, it's sort of the reverse question. Jurisdiction is territorial and it's absolute, but it's narrow. If you're here, you're born here, you're from here, you are subject to our jurisdiction, but there are things that are set outside of it. That jurisdiction can be waived, but otherwise the power of what was once the crown, now the American government, is necessarily exclusive. Our jurisdiction is over our soil. This foreign warship is not subject to that jurisdiction. That starts to matter in subsequent cases. Then the bad thing happens. Early American life was consumed in part by debates over slavery. Many of the southern states of the United States had tens of thousands of enslaved persons from Africa. Most northern states had abolished slavery. Fundamental problem in the creation of the United States. The founding documents, our Constitution and early amendments, were the subject of a compromise. It was known as the Missouri Compromise, which counted slaves as partial people, known as the 3/5 Compromise. They were not counted as full humans. People of African descent were not citizens. Sanford came to the Supreme Court seeking the Supreme Court's assistance. The Supreme Court said, Sanford, you are not a citizen because you are of African descent. It doesn't matter if you are enslaved, if you are free. If you are of African descent, the Supreme Court said in 1857, well, a majority of them said, you were not, could not ever be a citizen. Chief Justice Taney, who wrote the opinion, believed that citizenship was a status that the government could bestow at its discretion, and that the founders of the United States had chosen not to extend that status of citizenship to people of African descent. Because of that, the courts of the United States had no jurisdiction over these people because they were not citizens. I think this is widely regarded as probably the worst decision in American legal history. I don't think that's a controversial statement. I hope that's not a controversial statement. But that was 1857. In the late 1850s and early 1860s, the United States fought its Civil War, a battle between the northern free states and the southern slaveholding states over many issues. One major issue was the status of people of African descent and the legality of slavery. Following the Civil War, the North won. Again, hopefully not a controversial statement, but maybe. The Congress of the United States, seeing the Dred Scott decision coming out of the aftermath of the Civil War, enacted 3 amendments to our Constitution, the 13th, 14th, and 15th Amendments. The 13th abolished slavery, and the 14th definitively answered the question of who is a citizen of the United States, which had never before been answered in our codified law. All we had was the Dred Scott decision, which was based on common law, an interpretation of the common law. Congress codified and the states adapted the 14th Amendment. The first clause of the 14th Amendment is the Citizenship Clause. And it reads, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. The U.S. is a federal system. We have now 50 states joined together in a federal union. So you are a citizen of that federal union, and you're also a citizen of the state where you reside, or really domiciled. Seems uncontroversial. The problem is that subject to the jurisdiction thereof language. When this amendment was being debated in the 1860s in Congress, senators said on the record that this clause was simply declaratory of the law of the land already, that every person born within the limits of the United States and subject to the country's jurisdiction is by virtue of the law a citizen of the United States. There were concerns expressed in the Congress in 1868 that that would extend citizenship to children of immigrants. And senators said yes, that all children of all parentage would be treated as citizens of the United States as long as you are born or naturalized in the United States and subject to our jurisdiction. So not particularly, it seems from the records, controversial. This became an issue again in the late 1800s as the United States experienced new waves of immigration from places that were not Western Europe, particularly from China. Many Chinese nationals came to the west coast of the United States, mainly to the state of California, in response to widespread discoveries of gold and other minerals, known as the Gold Rush, started in 1849. Chinese immigrants built most of the railroads that crossed the United States. There was a treaty in 1868 that expanded migration and trade between the United States of America and China, but it did not address the question of citizenship of children born to Chinese parents on U.S. soil. There was a rise in anti-Chinese sentiment, and Congress passed what was called the Chinese Exclusion Act of 1882. Chinese people who were already present in the United States could stay, but they could not naturalize. And if they left the U.S., they would have to reapply for admission to come back. This led to the Supreme Court's decision in Wong Kim Ark. Wong Kim was born in San Francisco in California to Chinese parents. They were permanently domiciled in the U.S., but they were not eligible for naturalization. As a child, he traveled to China with his parents. His parents stayed in China. He came back to California, to the U.S., and worked as a cook. He went back to China to visit his parents, came back again in 1895 after the passage of the Exclusion Act, and he was denied re-entry in the port of San Francisco on the theory that he was a Chinese subject because of his parents' nationality. And he was detained on a ship for 5 months off the coast of California. His case eventually came to the Supreme Court of the United States, and in 1898, the Supreme Court ruled 6-2 that Wong Kim Ark was a U.S. citizen at birth because of the 14th Amendment. Because when he was born, he was physically here, and he was subject to the power to the jurisdiction of the United States of America. The Wong Kim Ark court recognized that there are 4 exceptions to the 14th Amendment. First, if you are the child of a foreign sovereign or a diplomat who was born in the U.S., you aren't subject to the jurisdiction of the US. You are physically here, you're born on our American soil, but we have a legal fiction that if you are born to a person who is here as a diplomat, that diplomat is not subject to our jurisdiction because diplomatic immunity. If you are born on a foreign publicly owned ship, you're not subject to our jurisdiction. If probably not controversially, if you are a child of an enemy force who happens to be occupying the United States, we're probably not going to say you're a citizen. And then at the time, children of Native American tribes who were not taxed. That has since changed, but these 4 exceptions were seen by the Supreme Court in 1898 as it. That's the cap. 2 justices said, no, even with the 14th Amendment, we should approach this from a jus sanguinis idea where we're going to look at the parent's allegiance, because how can you be subject to jurisdiction if you owe your allegiance to a foreign government? But that was a minority view. It was rejected by the majority of the court. And so the Supreme Court in 1898 said, if you were born here and subject to our jurisdiction, you're not under those 4 exceptions. You are a citizen of the United States. Interestingly, though, the court did sort of say we're breaking away from English common law now because we have the 14th Amendment. Fast forward 100 years. Really not controversial. The question of who is a citizen has come up in lower courts, but the Supreme Court had never really heard another case about nationality and citizenship and who is a citizen for purposes of the 14th Amendment until President Trump enacted his Executive Order 14160 in seems like yesterday, last year. There has been some scholarship from professors at American law schools debating the scope of the 14th Amendment and whether it actually means that if you are born here and subject to our power, you are a citizen or not. It's been a long debate about whether it's actually jus sanguinis and whether we take into account the allegiance of the parents. That led to the Trump administration siding with that line of thought, adopting an executive order interpreting the 14th Amendment for all American federal government agencies. Under our constitutional system, Congress passes the law, president enacts the law through executive agencies, things like the Department of Homeland Security, the Immigration and Customs Enforcement, ICE. All of those agencies report to the President of the United States. And so the president interprets the laws passed by Congress that can then be taken to the Supreme Court, who is the final voice of law. But the president, through executive orders, and you'll see how many of them we have, that's 14,160 just for President Trump. There's a lot of executive orders. So we had a new executive order where the Trump administration says we are going to interpret the 14th Amendment to not extend birthright citizenship universally. And it created 2 new categories of people who would be excluded from citizenship. First, if it added mother and father to the list of definitions for our nationality law and said that first, if the mother of the child was unlawfully present, or if the father is not a U.S. citizen or a lawful permanent resident, the child would not be a citizen, even if they are born here. Or if the mother is present lawfully, but temporarily, if they're here as a visitor, a visiting visa, tourist visa, a student visa, the father is not a U.S. citizen or a lawful permanent resident, that child will not be a citizen. And mother and father are biological parents only. This would have created major problems around the country if it had allowed to go into effect. Lawyers representing eventually the plaintiffs in the final Supreme Court case argued that hundreds of thousands of children in the United States would have been denied citizenship. So we would have a new subclass of people who lack the full rights and protections. And if they didn't have U.S. citizenship, many of those children would also be rendered stateless because they would not be a citizen of any country. And so they would lack access to services in the U.S., but also if they were deported, they would be deported to a country where they would never have lived. They might not be a citizen or national of that country and would not have access to services there either. And so the welfare of these children, babies, since we're now a year out from this executive order, would have been endangered. So a number of organizations filed lawsuits. They were consolidated into a case with 3 plaintiffs who were challenging the order on their individual behalf and on behalf of all other people who would be affected by this executive order. They used fake names. So Trump v. Barbara is not actually her name, but Barbara was an applicant for asylum from Honduras. She was pregnant at the time with a child due in October of 2025. Susan was a citizen of Taiwan who was in the U.S. on a student visa. Her daughter had already been born. And then a Brazilian national, Mark, not his real name, had applied for permanent residence. His son was born in the U.S. on March of 2025, initially had received a U.S. passport. The federal court where they started their lawsuit issued a temporary order barring application of the executive order nationwide to all children who would be affected by the order. That decision was taken on appeal to a federal appellate court, and before that federal appellate court could do anything, the Supreme Court of the United States intervened at the request of the government because this is something that they believed needed to be decided as fast as possible since children were being born. So that took a little under a year to be briefed. Oral arguments in front of the Supreme Court were held. And earlier this year, the Supreme Court issued its decision. And a very narrow majority of the U.S. Supreme Court, 5-4, agreed with the Wong Kim Ark decision and said that the citizenship clause of the 14th Amendment guarantees birthright citizenship to every person born in the United States to parents who may be unlawfully or temporarily present because the children are, quote, subject to the jurisdiction of the United States within the meaning of the 14th Amendment. 5-4. Most legal commentators in the U.S. were surprised that it was that close. I think many projected it would be, if not a unanimous decision, close to unanimous. So 5-4 was a surprise. The actual judgment was 6-3. Justice Kavanaugh didn't agree with the constitutional interpretation. He said that that federal code was not exhaustive, and so he said it was up to Congress to do it. But he didn't agree with the constitutional analysis. So it's technically 6-3, but it's not really 6-3. Interestingly, the majority's decision is, in terms of length of writing, less than 20% of the words written in this case. The judges who disagreed wrote about 70% of the written decision. They are much longer decisions. Justice Jackson wrote an opinion concurring in the court's decision, in the court's judgment, very strongly worded attack on the legal analysis in the 3 dissents. Well worth a read, in my opinion. It's beautifully written. The majority decision, which was written by the Chief Justice, basically tracked everything I've talked about. It talked about the schooner exchange decision from 1812, about how the narrow exceptions to the territorial jurisdiction of the government. It talked about at length the Dred Scott decision and the Wong Kim Ark decision, and then brought us to 2026. I'm seeing a couple of questions in the chat. Is there discrimination on biological and adoptive parents in terms of rights in the U.S., not regarding immigrants? Do you mean by the government, by people? I don't think I entirely understand the question.
Right. So this question would be related to that part where you were discussing that it would only biological parents that would have certain specificities in terms of being considered the national or not. But then it came to my mind that maybe there are any laws in the US that would say that there is, because of their biological parents and not adoptive parents, they would have certain rights that adoptive parents would not, or adoptive kids would not. Like, because in our constitution, at least in Brazilian constitution, we cannot discriminate adoptive children to biological children. So I'm not sure if there are any in the US any laws or any discrimination in these terms, or if it's normally equal. And then in that part, when they mention that it would be only biological parents, does that have like a more maybe weight to that decision, to that interpretation?
So there's a short answer and a complicated answer. The federal constitution doesn't really contemplate adoption. Family law in the US is largely left to the several states to handle. So there is some constitutional protection. So post finalization of an adoption, adoptive parents have identical legal rights as biological parents. And then if an adoption happens, biological parents' rights are generally extinguished. Before the adoption is finalized, there's some asymmetry in terms of the federal constitution. Biological parents who've established a biological relationship have a recognized liberty interest under the Constitution. Prospective adoptive parents don't have a constitutional liberty interest before the adoption is finalized. Their interest is statutory. Does that make sense? And then state laws can vary widely on the rights given to prospective adoptive parents. So it really depends on where you're located.
But in Brazil, for instance, there's a discussion concerning what would be, or there was a discussion in the past, and what would be the nationality of children that were adopted, but if they were born abroad, and if they would be considered, for instance, in Brazil, let's say a Brazilian by birth, or if they would be considered like a secondary Brazilian by acquiring Brazilian nationality through adoption. And I was wondering if in the US they would be then considered, if it was a child born abroad but then adopted by American parents, if they would acquire American nationality considered by birth, because that would not contemplate the 14th Amendment that you just mentioned, isn't it?
Right. So the 14th Amendment applies only to persons who are born in the United States. So a child who is born abroad and adopted by U.S. citizen parents would acquire citizenship through statute, not through the citizenship clause of the 14th Amendment. And there are federal laws governing how adopted children would be nationalized. There are pathways to and it also depends on who the parents are. So if one of the parents is a U.S. citizen, biological parents, I should say, of the adopted child is a U.S. citizen, including the adoptive parent, they could have a pathway to automatic citizenship. But it's not, they're not natural born for purposes of the 14th Amendment. I see another question. Is it common for the U.S. Supreme Court to intervene before an appeals court decides on a matter? No, it is not common. It is uncommon. There are formal procedures to have that happen, which is what happened here. The federal government sought an extraordinary writ of review from the Supreme Court and requested that expedited briefing. We weren't surprised that it was expedited, but it is certainly not common. And often the Supreme Court rejects those requests because they want every layer of our court system to weigh in before they take a case. The Supreme Court of the United States hears about 90 cases a year. They get requests for about 25,000 cases a year. So it is extremely unlikely to have your case heard by the Supreme Court at all. And so that extra layer of they got the expedited review was very it was unlikely, but not surprising that they did it. In terms of the 5-4 decision, it doesn't matter for the legality of the decision that it was 5-4. If it's the majority of the Supreme Court issues a ruling, that is the binding ruling. It matters in that the American court system has this idea of stare decisis, where we give weight to prior judicial decisions. We don't like to overturn prior judicial decisions unless there is reason to do so. This Supreme Court has taken a slightly different approach to that doctrine. They are willing to revisit older decisions if they think they were wrongly decided, which is a good thing, can be a bad thing. The issue with this being 5-4 is if it comes back later, it's easier to say, well, they got it wrong because it was so close. So if it had been a unanimous decision, it's harder to argue. It's not impossible to argue, but it's harder to argue that the court got it wrong. The Trump administration, after this decision came down, said they were going to formally request that the Supreme Court review their decision and decide again whether they were correct. That you are allowed to do that. It is extremely uncommon for the Supreme Court to reverse itself that quickly. And in fact, the Trump administration didn't file that request ultimately. They may have changed their mind, but the time for that formal reconsideration has passed. So what would have to happen now is a brand new case that would have to start off in the lower courts and get all the way back up, and the Supreme Court would have to agree to take it. Which could happen. But the Trump administration instead chose to issue two new executive orders. And those came out about 6 days ago. And then there's a follow-up question. This happened recently with women's rights. Yes. So the Supreme Court 2 years ago reviewed its earlier decisions on a woman's right to an abortion. Roe versus Wade, which was decided about 30 years ago. The Supreme Court, I think 2 years ago, it's all starting to run together. The Supreme Court about 2 years ago revisited that decision, and a majority of the court said that Roe v. Wade was wrongly decided and reversed it. So that's what I'm saying. It's possible for them to do it. If the court believes that an earlier decision was wrongly decided, they can revisit it in a new case. And so it being 5-4 makes it a little more scary that this could come back. That would take probably at least another year because we would have to go through that whole process. And it's not guaranteed that it would get back to the Supreme Court. The court could choose not to take it because they just decided it. And we think that that's probably likely that a majority of the court would say this is now settled law. We're not going to revisit it. Yes, in the Roe v. Wade decision, there were more, I don't know if they were appointed by Republicans and Democrats have sort of changed who would be considered classically liberal. And so I can't say for certain whether they were appointed by liberal Democrats. Certainly a more liberal court. The Brennan court was much more liberal. Yes, there are more justices on the Supreme Court now who were appointed by Republicans. So, trying to find there we go. We have 2 new executive orders as of last Thursday. The Trump administration has 2 new ones. We have a executive order interpreting the Supreme Court's interpretation of the law, which is Executive Order 14418, continuing to protect the meaning and value of citizenship, in which the Trump administration characterizes new, I guess, problematic interpretations of the 14th Amendment, some of which are already covered by other federal laws. Like, we don't really need some of these interpretations. The other is a attack by the Trump administration on what they call birth tourism, where pregnant women travel to the U.S. for the purposes of having their child on the territory of the United States to take advantage of the 14th Amendment so they can have their children be permanent lawful citizens of the United States. My understanding is there's very little evidence of birth tourism actually happening. The Trump administration believes that hundreds of thousands of women are traveling here pregnant to have babies in the United States. This order is 6 days old, and there is already a lawsuit against it, brought by the same lawyers and some of the plaintiffs from Trump v. Barba. And they say, and I'm going to quote it because it's a great quote. They say that, quote, if the president issues 100 orders seeking to create new exceptions to the sacred guarantee of the Citizenship Clause, all 100 will be equally illegal. Nothing requires the court to countenance the continued assault on this foundational constitutional principle or issue an endless string of orders preventing these executive orders from going into effect. So they're saying, like, we're done. We don't need to do this. The Supreme Court's already said they are the final voice on the law. We don't need to do this. But we're going to do it again and again and again and again. The plaintiffs are saying that the Supreme Court didn't leave a vehicle for the president to create new exceptions to the Citizenship Clause. Congress would have to do it via a new amendment. And these new exceptions are actually broader than the narrow exceptions the Supreme Court recognized going back to Wong Kim Ark. So I think we're going to see more litigation about it. I don't personally think it's going to go back to the Supreme Court of the United States. Personally. But it might.
Right. So it's quite interesting because on considering the tourism, birth tourism, we know there are many Brazilians that go to the U.S. in order to have kids, for their kids to have the American passport. And when, if I'm not mistaken, then you can correct me if I'm wrong, when they turn 18, they could ask for their parents to join them as being Americans. Isn't it right?
So that has been part of immigration law. Congress has been working on changing that, so I can't say for certain if that's still possible.
I see. But these changes on immigration law, they have been coming up for, or they have been developed for the past, let's say, 2 years, isn't it? And possibly because they keep on being pushed by these executive orders that Trump has been publishing or ordering in an event, considering this interpretation on giving rights to people that are not actually U.S. citizens, as per having this long tradition in their family as being Americans. Is it correct? Right. But then we have the very example of his son. Isn't it true? Because Trump's wife is not an American, but then his son Barron is, isn't it?
Yes, but he was born in the United States and subject to our jurisdiction. So, but yes.
I see.
Yeah.
Right.
The one thing, I mean, many things worry me about these executive orders. One that concerns me about the birth tourism one is the order really leaves it up to the agent looking at the visa applicant to determine, are they pregnant at all? And if the agent believes that they're pregnant, then if the agent believes they're pregnant and they want to come here to have their baby, they can deny the visa. That's a lot of discretion, and it's invasive.
And are there any laws considering this part on the right to privacy that would be?
So the Supreme Court, in a
message?
different decision, recently said that people who are seeking entry to the United States are not in the United States yet for purposes of protection by American law. They're in a sort of null territory, but they're not yet subject to the jurisdiction of the United States for purposes of those protections.
Even if they applied?
Uh-huh.
Oh, I see. And does this apply for the T visa kind?
It applies basically for everything. The decision was about asylum seekers. So even if you're seeking asylum, but you have not yet physically entered into the United States, you are not within the scope of American law yet in terms of seeking those protections.
Doesn't this actually go back to those decisions regarding the legal black hole on Guantanamo?
Yes, in part.
And how come in part?
Guantanamo is a special situation because of a treaty agreement with Cuba about what exactly Guantanamo Bay is in terms of territory of the United States. But the underlying idea of you're either in the United States or you're not is definitely a part of this.
And do you think it would change what has been interpreted in terms of guaranteeing at least basic civil rights to those applicants if this discussion goes up?
I think the U.S. is going to have to consider, for example, its non-refoulement obligation in thinking about where asylum applicants are physically. So I think we have some problems to figure out.
Because non-refoulement has been applied by the European Court of Human Rights, by the Inter-American Court of Human Rights, but even if we consider the OAS and the Inter-American Commission, to which the U.S. would then be part of, it wouldn't be necessarily applicable to the U.S. to reaffirm, or is there a specific law in the U.S. that also talks about non-refoulement?
So there is, but the Supreme Court says you have to be in the United States. And so if you're seeking entry, you're not yet here. Or if you're here unlawfully, we're really drawing a very, very distinct line that I don't think is supported in international law on who is entitled to these protections.
Right. But then let me go back a little bit. Then we're talking about having people that then are illegally in the country. So they would create a subcategory of citizen or of person in the US that would not be entitled to the full amount of rights that others would have?
Well, so the decision I'm talking about said that non-citizens do not arrive, using quotation marks, arrive in the United States until they physically cross the border. So if you are waiting at the border, if you're on a bridge, if you're at a port of entry, you're not physically on U.S. territory, you don't have a right to be processed for asylum because you're not here.
Okay, so this would apply for the southern border in Mexico, where they're keeping asylum seekers in Mexico in order for them not to be...
right, and so the U.S. government has no legal obligation to process a asylum seeker's application if they're on Mexican soil. Even if they're like on a bridge, if they're in an American port of entry, they're not actually in the United States yet. And so we have no obligation to them.
So they could be returned or be even like not even analyzed. That would be all. Okay. But then if we consider a person to be in the U.S. Illegally, it doesn't matter for how long the person is there. It doesn't matter if it has if the person is married to an American citizen, so that person would not be entitled for certain kind of rights. Is that the what we are discussing possibly
That's
for
the
this
Trump administration's
administration?
interpretation, yes.
I see. And this is why we have those cases of ICE arresting people and then just taking them off the country, but then they could not apply for stays when they are being processed to be returned to their home countries.
Yeah, so there are processes if you are physically in the U.S. to request asylum. It is becoming increasingly complicated. Immigrations and Customs Enforcement has been constantly issuing new regulations on when and how you have to seek that assistance. And if you don't meet every single one of those, you can be removed. And ICE and Customs and Immigration have been actively seeking to deport as many people who are here unlawfully as possible, because then they don't have to be processed at all.
I see. And something that we have seen, for instance, in some European countries, as per having preference over nationals from a certain country. For instance, now in Germany or even other nations, there are cases where they rather take in Ukrainians instead of Afghanistan people, and then or Afghans. Then I would ask: is there a certain preference in the U.S. for people being targeted because of their country of origin, or they're just trying to actually remove all of those people that are in the U.S. illegally?
So, not as a matter of federal law, the U.S. doesn't have a list of priority asylum applicants, but every single one of, to my knowledge, every single one of the refugees admitted legally to the United States, and I want to say in the last 6 months, was a white South African.
Not even people from, let's say,
the data that I've seen, I think every refugee admitted in this calendar year has been from South Africa. 3 from last year were from Afghanistan,
3. Okay.
and that's it.
Right. And you said when you were talking about these executive orders.
Just to add a
Yeah,
little extra layer, in the last calendar year, the U.S. has admitted about 6,000 refugees. In 2024, the U.S. admitted about 100,000 refugees. So the number has gone drastically down.
and of course, this implies also a political perspective of the Trump administration in terms of also its aid agencies and not only not assisting any more
Yeah.
countries, for instance, in Africa, or even considering those places where there are some active conflicts.
Mm-hmm.
But then my question would be, basically, do you see these practices through administrative orders or these executive orders as being or having a point of illegality specifically in terms of the Constitution, or this would be actually just going ahead and having the same interpretation of Clause 14, Amendment 14th, or there are other clauses that we could discuss for finding illegal grounds on these orders emitted by Trump?
So on these the 2 that we just have from like 6 days ago, this is the administration's interpretation of the Supreme Court's decision on the 14th Amendment. So they're saying this is how we understand what the court said. So they're not invoking a new basis. They're using the same basis. They're just interpreting what they think the Supreme Court meant. So no. Things like the tariffs, the Trump administration has tried different legal theories. They, so far with birthright citizenship, have not. They're just doing the same one, but cloaking it as, we see the Supreme Court, here's what we think the Supreme Court says we can do.
And at the end of your talk, you mentioned you don't believe these new executive orders would go back to the Supreme Court because the Supreme Court has just decided
Yep.
On the matter. Are there any examples where the Supreme Court has given two sentences in a very short time relating
Yes.
to the very same time,
Yeah.
same topic?
So it's possible. So what I think could happen at the Supreme Court, and the reason that I say I don't think it will come back to the Supreme Court is I think the lower levels of our federal courts will use the Trump v. Barbara decision to say that we're done. Like, this is finished. And if it gets back to the Supreme Court will issue just kind of a one sentence affirmed, period.
Interesting.
I don't think they will have another round of like arguments and briefing and a new written decision, unless
I'm sorry.
Unless the makeup of the court changes and we see like 2 or 3 new justices appointed who would agree that the decision should be revisited. But I think that's unlikely.
Are we seeing to have new justices appointed in the U.S.?
We thought we might have a new one, but it would have been a replacement for Justice Alito, so it wouldn't have changed the overall composition of the court. So it's unlikely.
I see. And considering now the procedural aspects, probably you said that there are cases already discussing these executive orders in first instances in the US, but then could there be different prescriptions regarding courts of appeal and the circuits having different interpretations, or do you see this as having the same basis for all circuits in terms of appeal courts?
So it's possible, certainly, that the federal appellate courts could disagree. I don't think it's likely because we have such a recent Supreme Court decision, and most, I can't say every single one, but most, if not all, lower federal appellate judges are going to defer to the Supreme Court. They may say something like, I don't like the decision, I don't agree with it, but I am bound by it.
Interesting.
There's very few instances ever of a lower federal judge just openly rebelling against the Supreme Court.
Interesting.
Now, they may write a decision saying, like, I have to do this, my hands are tied, and I'm going to write 150 pages of why I think it's wrong. That happens all the time. But the actual judgment will be what the Supreme Court said it has to be.
Huh. But then it could serve as basis for other inspirations for new executive orders, right?
Or a brief to the Supreme Court saying, look at what this very intelligent lower court judge said. Your Honor should look at that. Yeah.
I see. So on a final word, what do you think about all these discussions regarding birthright in the U.S. and having these executive orders and having these processes of basically taking rights from people for being in the U.S., considering that normally the U.S. was thought to be the land of opportunities, the one that receives immigrants from all over the places, and so on and so forth. How do you see that as an implication for the United States foreign policy, and particularly its potential repercussions for international law? Very wide question.
That's a lot of questions. So first, I will say I was really shocked that the decision was as close as it was. I think that the law on this was pretty clearly established by the 14th Amendment, and really even before the 14th Amendment, I don't think this was a question. And I would characterize the scholarship leading up to this decision going the other way as really not being the mainstream. It was a few scholars who were going in the direction of birthright citizenship not being protected by the 14th Amendment. So I was surprised that so many justices on the court agreed with that. I really expected it to be unanimous. international law has always had a complicated relationship with U.S. law. The U.S. Constitution recognizes international law as a source of law, but it's very rare that our courts rely on it. So I don't think that will change. I wish that it would, as a professor of international law. And so I don't think the overall attitude towards international law has changed. I think the U.S. has been and will remain to be fairly hostile to the idea of any government other than our own dictating rules that the United States has to follow. We are the classic example of a persistent objector. And I think we will remain the classic example of a persistent objector to every principle of customary international law that you can think of. I think we will probably withdraw from some additional treaties in the future. I think, like most states in the world, we like international law when it's good for us. And we don't like it when it's not. And I think most American politicians generally see international law as hostile to the interests of the United States.
I would say that the measures taken early this year by, of course, taking the U.S. out of many international organizations and some treaties, it reinforces what you say, that basically we have seen this in the past, but very specific to certain situations, let's say for the Paris Agreement or but never this wide, never in this high numbers. So
so what I think is interesting there, though, is we have been removing ourselves from international organizations, but also creating new ones. That so the Board of Peace, for example, that's a creation of the Trump administration. It's a international organization governed by principles of international law, as sort of a different version of the United Nations.
But still having the American president as their
right
executive, like for a long time to be
yes.
Board
so I think it's we like international law when we think it's going to be good for us. So we the United States, not me, because I'm certainly not doing any of this, are creating international organizations to suit the needs and interests of the United States and withdrawing from ones that we don't think are valuable for us. And I don't think that that's helpful for the rule of law, but at least it's some recognition that the U.S. thinks international law is real.
Interesting.
I'm trying to find the good.
Yeah, definitely. Right. So, well, I would say that those were the main questions and topics we could relate to this idea. I think we could indeed schedule another appointment to have you talk about U.S. and no, I mean the treatment of indigenous peoples in the U.S. and how does this relate to the
that would take like a day.
And it would be really, really nice because then we can make some comparisons to the treatment of indigenous peoples in other countries too. So it would be amazing. So I will let you with this open invitation for
I would be happy to do
back. And I would
next time I'll come in person.
Oh yes, we could arrange that. Actually, we should do that. But then I would love to take this opportunity also to thank you for your time and for preparing the material and for talking to us openly about the U.S. and how do you believe some things are not correct from the U.S. Point of view, and this is something that in my perspective, it should be really done more. But sometimes people are kind of scared of speaking out in certain topics. And then thank you very much.
Happy to be here. Thanks for doing this.
All right. So Obrigado a todas e todos que assistiram. Nós voltamos, então, com o nosso próximo Diálogos em Direito Internacional numa próxima quarta-feira. Tchau a todas e todos. Muito obrigada.